The second respected presenters are Ms. Priya Fasikawa and Ms. Lasata Duwal, titled From Judicial Recognition to Legislative Reform, Advocating Codification of Battered Women Syndrome in Nepal's Criminal Law. Similarly, the third respected presenter is Ms. Sadiksha Khatiwada, titled पीडितबाट अपराधीसम्म घरेलु हिंसाको सन्दर्भमा ब्याटर्ड वुमेन सिन्ड्रोम र परम्परागत आत्मरक्षा कानुनको पुनर्विचार. The fourth respected presenters are Ms. Ojana Bosyal and Ms. Neha Kumari Gupta, titled Self-Defense and Battered Women Syndrome in Nepal. The fifth respected presenter is Ms. Sristika Vajracharya, titled Legal Relevance of Battered Women Syndrome Defense. The sixth respective presenters are Ms. Subeksha Pokhrel and Mr. Sher Bahadur Buwar, titled Criminal Liability of Abused Women, Integrating Battered Women Syndrome into Justice Framework. Now, we will be going forward with our presentations. For this, I would like to call the second presenter, Ms. Priya Fasikawa and Ms. Lasata Duwal, titled From Judicial Recognition to Legislative Reform, Advocating Codification of Battered Women Syndrome in Nepal's Criminal Law.
Thank you, Rajita. Thank you. Much better than the jumping very bad, so it just facilitated the entire process. So okay, some have a call up for the first presenters were not here. That's why we're starting with the second one first, right? So Manashi Baslet, are you here? Perfect. Okay. So you'll be going second, right? You'll be going second. So that's that one. This what she's having. We'll follow the order as scheduled, right? Thank you. Priyaji, welcome to the session. Are you going to start now? Error podcast. No worry, please don't worry. You fix the corners team, and while you're fixing that. So actually, sorry, I'm really sorry. Before you start, we have to read out the rules. I think so. I'm reporting to
Before we begin, I would like to briefly explain the session procedures and time management guidelines. First of all the presenters and participants are requested to switch off mobile or keep it on silent mode. Each presentation will be allocated 10 minutes for their presentation. A warning bell will ring at the completion of 8 minutes, indicating that only 2 minutes remain for the presentation. A final bell will ring at the completion of 10 minutes, at which point presenters are kindly requested to conclude their presentation immediately in order to maintain the conference schedule. To ensure equal opportunity for all presenters, we respectfully respect strict adherence to the allotted time. The question and answer session will be conducted only after all 6 presentations. Following the question and answer session, the respected session chair will provide comments, observations, and concluding remarks for 15 minutes. Now, we should move forward with the presentation.
Yes, good morning everyone. I'm Priya Fasikawa along with my co-author Lasata Duwal. I'm presenting on the paper. We are presenting on the title of paper titled From Judicial Recognition to Legal Reform, Advocating Codification of Battered Woman Syndrome in Nepali Criminal Law. This paper examines an important question with the criminal law and domestic violence jurisprudence. If Nepali courts have already recognized the realities of battered woman syndrome, why has Nepal still not incorporated it into its criminal legal framework is a major question that our presentation seeks to address. Domestic violence is usually just viewed as a family issue, personal family issue, while it is not a personal family issue. Instead, it's a serious social, psychological, as well as physical, legal issue. In some situations, women who have suffered years of abuse eventually retaliate against their abusers, sometimes causing serious injury or even death. At this point, traditional criminal law faces a challenge. The law generally expects the person claiming this self-defense to have this the threat was they must have immediacy and imminence. So, but what happens when the threat is not at a single moment, and what happens when the threat has been existing for every day for years? This is where battered woman syndrome becomes relevant. Can traditional criminal law adequately understand the reality of prolonged abuse? This question is the central of our paper. So our study has three major primary objectives. Firstly, it is to understand the concept of battered woman syndrome and its place within the criminal law. And secondly, to analyze the judicial trend regarding the BWS in Nepal. And thirdly, to evaluate whether Nepal should formally incorporate BWS into its criminal justice system. To achieve these objectives, we have adopted a doctrinal and analytical methodology and examined statutes, judicial decisions, scholarly literatures, and comparative jurisprudence. So, what is BWS or battered woman syndrome? It is a psychological theory developed by Leonard Walker to explain the behavior of certain women who suffer from prolonged abuse from their husbands, their partners, or their lovers, or whoever their intimate partners are. Importantly, BWS is not an excuse for violence. I'm mainly highlighting this point that BWS is not an excuse for violence. Rather, it is just a framework that helps the court understand that how prolonged abuse affects perception, decision making, and responses to danger. Going on with the key features, firstly, the battered woman faces the continuous fear. Secondly, they have whatever decision they make are based on trauma. And thirdly, they have the perception of inescapability, that they cannot escape whatever the situation they are currently in. And finally, it's their alternate response to the threat. As a result of long-term abuse, they cannot respond to the danger as what is expected by the traditional criminal law as how a reasonable person behaves. So, going on with this, it is necessary to understand the two core components of the battered woman syndrome as described by Leonard Walker. That firstly, it's the cycle of violence theory. Walker has identified what she called as cycle of violence, incorporating the cycle of violence consists of three stages. Firstly, it's the tension building stages where the conflict gradually increases and the victim attempts to avoid provoking the abusers. Second stage is acute battering, where the severe physical and psychological violence occurs, whereas the third stage is reconciliation, where the abuser promises changes and behave lovely. However, the situation just goes on, and the cycle continues. The cycle of the violence continues. And the second concept within the battered woman syndrome that we have to understand is learned helplessness, which states that when a victim is abused repeatedly, over time the victim may begin to believe that escape is impossible, even when a normal outsider thinks that alternatives exist. This theory helps to explain a question frequently asked in domestic violence cases: why doesn't she just leave? Because the answer is that the years of abuse have fundamentally altered a person's perception of available resources that a normal human can think. So having explained these psychological foundations, my co-author will now discuss its legal framework in Nepal and examine how judicial trends and Nepali court has addressed this.
Good morning, everyone. I am Jestha and I will be continuing with the presentation. I will earlier discussed the concept of BWS and the psychological foundation of BWS. Now the question arises whether the Nepalese legal framework recognizes the social realities of BWS. At present, Nepal has two major legal instruments relevant to domestic violence and criminality. First, Domestic Violence Offence and Punishment Act 2066. It recognizes physical violence. It recognizes physical violence, mental violence, sexual violence, economic violence. The Act mainly focuses on domestic violence as offence. However, it fails to address what happens when a battered woman commits such offence. Secondly, the National Penal Code 2017, Chapter 12 contains provisions relating to homicide provocation and mitigation. However, this penal code does not provide any specific defense relating to BWS, neither does it provide a structured framework addressing the BWS. Therefore, the law remains silent regarding criminal liability of the battered woman. Despite the law remaining silent regarding the battered woman, the Nepalese Supreme Court has been the first institution to recognize battered woman syndrome. In the case of Doma Lamini, the court considered that Doma Lamini had been subjected to a prolonged abuse and mitigated her punishment of homicide to 10 years. Similarly, in the case of Lakshma Body, the case considered that she was, from earlier days in her marriage, she was subjected to physical and verbal violence, hence she would hate the person, hence these circumstances could lead to hate the person, so the court mitigated the punishment and punished only 7 years. Similarly, in the case of Jokumari Karki, the court finally coined the term BWS in its judgment. Now turning towards the most important case law in the field of BWS, Radhika Shrestha, the joint bench of Sushila Karki and Vaidyanath Upadhyaya not only recognized BWS explicitly, but also adopted Walker's definition and also stated to use expert testimony on BWS as admissible evidence its necessity, hence gave directive to formulate laws and policies related to it. Despite these progressive judicial development, there remain significant legal gaps. The major findings of our papers were how the judiciary has implicitly recognized BWS, and there has been gradual judicial development as starting from recognition of BWS to giving a directive to formulate laws and policies regarding BWS in Radhika Shrestha's case. Similarly, we can analyze that there has been no statutory recognition of BWS. Similarly, there has been over-reliance on judicial discretion as there is no structured framework regarding BWS. And we can also find that the traditional self-defense doctrine does not cover BWS as there may be lack of imminent threat in BWS. At last, there is lack of institutional infrastructure as there are no national statistical data relating to BWS. Even in the annual fact sheet on gender-based violence, we could not find any data relating to BWS. To carry on the further presentation, I will have to forward.
So, thank you. So, I'll now discuss why battered women syndrome should be formally recognized in Nepal's legal framework. Our paper has identified a few major reasons. Firstly, it supports the judicial consistency, as my co-author has already stated how the punishment has varied from 10 years and 7 years and again 10 years. So this it creates the consistency. And secondly, it reflects the social reality. The law should reflect the social lived reality within the society, which the incorporation of BWS within the law would address that. And thirdly, recognizing the psychological. Could I request for please?
in 1 minute.
Yeah, thank you. So, continuing on, it also recognizes the psychological impact, and again, it corrects the limitations of the self-defense doctrine, and it aligns with the evolutionary jurisprudence, as countries such as Canada and Australia has already recognized such within its criminal law, within its legal aspect. Going on with the recommendation and conclusion, based on our research, we have recommended several reforms. Firstly, Nepal should formally recognize BWS within its criminal legal framework, and secondly, our court should be empowered to receive expert psychological testimony when BWS is raised as a defense or mitigating factor. Thirdly, mechanisms should be established for psychological assessment of survivors by qualified psychologists and psychiatrists. And fourthly, national data, and as my co-author has stated, that it lacked the national data. So national data and institutional infrastructures relating to domestic violence as well as BWS should be developed. And finally, the direction used by provided by the court in the case of Nepal government versus Radhika Shrestha should be applied by the government to make such law. Concluding our presentation, Nepal has moved from judicial recognition of BWS but legislative codification is still necessary. Thank you.
Thank you, Priya and Vasudha. Wonderful presentation. And now we'll move on with the second presentation for today. So the one I'm calling out for is Manashri Basnit and Jena Sagrapati. Hopefully I'm pronouncing their names right. And the title of their paper is Criminal Liability of Abused Women in Nepal, a study of background movements.
Act 2074, which lists down the factors. Moving forward with the recommendation. One is legislative reform, that Nepal should enact a dedicated infanticide provision which is comparable to the Infanticide Act of England and Wales, with differentiated punishment ranges which treats infanticide completely different from intentional homicide. Second, the courts must apply the Section 15 of Sentencing Act, Section 17, and also Section 38 and 39 of the Criminal Code so as to determine specific factors that reduce or mitigate or aggravate the offences. And on systemic prevention, the state must expand access to contraception, safe abortion services, and provide financial support to destitute mothers. To conclude, the Supreme Court's jurisprudence on infanticide reflects genuine empathy, contextual intelligence, and a growing recognition of gender inequality. These are strengths, but empathy without structure provides unpredictability, and contextual sensitivity without doctrinal clarity can risk obscuring the fact that the center of every one of these cases is that a child died. Thank you.
Thank you, Professor. So, हामी चाहिँ यो डिस्कसन अन्तमा मात्र गर्छौँ एकमुष्ट र अहिले चाहिँ हामी प्रेजेन्टेसन अगाडि बढाउँछौँ र डिस्कसनको लागि तपाईहरुले नोट गरिराख्नु होला र अन्तमा चाहिँ हामी 5 वटा प्रेजेन्टेसन सकिएपछि मात्र हामी डिस्कसन फोरममा उपस्थित हुन्छौँ। अब नेक्स्ट प्रेजेन्टेसनको लागि प्रतिष्ठा ढकाल, सुस्मिता ढकाल, सर्भाइभल अर क्राइम।
Namaste everyone. I am Susmita Kharka, one of the co-authors along with Pratishtha Dakal of the research paper Survival and Crime, Rethinking Women's Criminality in Nepal through the lens of socio-legal thinking. At 5 a.m., when the streets are dark, quiet and uncertain, I get ready for my morning classes. And among the things that I pack for my morning classes, one choice stands out: a water bottle. Chosen not just for convenience, but for a sense of protection. One that is less about routine and more about survival. For me particularly, I would choose a glass water bottle, not because I intend to harm anyone, no, but because I am aware of the risks that I might face. Now let me ask you a question. In a moment of imminent threat, in a moment of danger, in a moment of necessity, if I use the very water bottle to defend my life, to defend myself, would my action be considered as survival or crime? This very question lies at the heart of our research. This very lived experience as a woman myself has given birth to this research. And if this is my reality, then imagine how many women have to face this every single day. Across Nepal, many women are pushed into actions that are later labeled as crime but are deeply rooted in survival. Thus, our paper argues that the women's criminality must be reinterpreted not as a deviant behavior driven by intent, but as an outcome of socio-legal failure to protect women from structural inequalities, violence, and economic marginalization. With the time constraint in mind, I will be taking you through various aspects of our research paper, and by the end of the session, I hope you will be able to answer the question that I just raised a few seconds ago. Now, what is survival crime? The idea of survival crime is not a new concept. In fact, it has been circulating in academic circles for years and years. However, in recent years, the idea of survival crime has emerged to describe situations in which individuals engage themselves in unlawful acts, not out of intent, but as a response to fulfill basic requirements for survival. This concept is especially relevant in Nepal. Especially relevant in context of Nepal, in our country, because socioeconomic inequality, gender discrimination, and limited opportunities significantly affect women's life. In an article by B.L. Boyer, it is written that a useful way to understand survival crime is that any criminalized conduct that affirmatively answers the question, does this action help me not to die, can be considered as survival crime. People who have been criminalized in this way do not offend because they lack discipline, but because they are disproportionately put in a position where they have no other choice. Hence, it is important to conceptualize that survival crime is fundamentally distinct from actions that are driven by criminal intent and is rather driven by severe conditions such as poverty, abuse, coercion, and structural deprivation. Now, literature review. The literature reviewed in this study indicates that women's criminality in Nepal cannot be understood in isolation from the structural condition within which it emerges. For example, the book Kara by Susila Karki forms a central foundation of this study as it critically highlights the realities of women prisoners in Nepal. Forced into an abusive childhood marriage, the protagonist faces an incarceration after killing her elderly husband in a desperate act of survival to protect herself and her infant son from the violent Kukuria dance. Thus, this book reveals that these structural conditions severely limit women's choices in life. It further emphasizes that the significant number of women in prison come from backgrounds characterized by poverty, domestic violence, lack of education, and social dependency. Moving on to the theoretical perspectives, these are some of the theories that essentially describe women criminality. Starting with labeling theory, criminal labeled women face barriers to social integration. Societal and institutional reaction trigger a cycle of exclusion from employment and family, pushing women deeper into illegal activities. Similarly, feminist and pathway theories talks about how women's criminality stem from victimization, abuse, trauma history, and patriarchal oppression. In Nepal, empirical data shows a single fiscal year recorded 911 domestic violence cases, while lifetime prevalence is 23.2% for physical, 12.8% for emotional, and 7.1% for sexual violence. Lastly, marginalization and strain theory shares that structural inequality, severe poverty, and block legitimate opportunities leave women with no choice and push women towards survival crimes. Ultimately, women's criminality is not an inherent threat, but a survival-driven response to systematic victimization, economic marginalization, and the exclusionary cycle of social labeling. Now, with the structural factors, first consider the psychological trap. The 2022 Nepal Demographic and Health Survey reveals that 1 in 4 ever married women experience domestic violence. Prolonged abuse triggers BWS, battered women syndrome, where the victim lives in a state of permanent fear, where her brain is constantly screaming that her life is at risk even in the moments of quiet. Tragically, Nepal police data shows that 73.17% of domestic homicide victims are women. When these survivors finally strike back, the system views them as perpetrators, ignoring that their act was a last-day self-preservation response to a system that routinely forces family rehabilitation over victim safety. Second factor, let's look at the socio-economic case. ORIC Nepal report shows that 34.3% of violence survivors work entirely within their own households with zero independent income. Trapped in poverty and lack of land ownership, women are forced into survival crimes like petty theft, drug transport, or prostitution just to sustain their life. We see this acutely in the historically marginalized Bali community, where systematic neglect turned prostitution into an entrenched survival mechanism passed down through generations. Ultimately, under the UK criminal code, these acts are viewed as crime. However, in reality, most women's criminality in Nepal is not an inherent threat, but a survival-driven response to institutional failures. Now moving on to international and national and legal scape. Survival-driven crime is yet to be codified. However, it has been addressed via battered women syndrome and expanded self-defense. International landmarks cases like State versus Kelly and R versus Level establish that an abused victim's perception of danger must be assessed contextually without a narrow focus on immediacy. However, in context of Nepal, Section 22 and 24 of Muruki Criminal Code visibly require an immediate threat for self-defense, completely failing to capture ongoing abuse and psychological coercion. However, our judiciary acknowledges this gap, but inconsistently. In a case of Radhika Shrestha versus Government of Nepal, where a victim of repeated battery killed her husband by fire, the Supreme Court explicitly ordered the state to introduce laws regarding battered women syndrome. Similarly, in cases of Kumar and Karki and Lakshmi Bali, courts consider severe domestic violence and economic status to reduce sentences under the old military act. Furthermore, cases like Kusma and Odi Bista reveal young women committing infanticide due to rape, abandonment, and severe social stigma, low class. While our current judicial approach shows leniency and treats BWS as a mitigating factor, these recognition is applied broadly without deeply engaging with underlying socio-economic and survival circumstances. Consequently, a firm jurisprudential foundation for survival-driven narratives remain underdeveloped in Nepal's legal system. Now, turning to our empirical findings, data from the Crime Investigation Department clearly reveals that socio-legal failure over a decade. While female literacy rate climbed by 20%, violence against women surged by 42%, with cases spiking from 8,000 to over 20,000 by 2079 and 2018. Our primary survey of 100 students strongly reinforces this data. 25.8% identified domestic violence as the primary cause of female crime. 80.3% recognized that abuse drives women to become offenders, and 84.7% agree that courts should issue lighter, rehabilitative punishments for survival-driven acts. Our analysis and finding reveal a critical gap. Women criminality in Nepal stems from structural inequality, economic dependency, and domestic violence rather than deliberate criminal intent. When trapped in these constrained circumstances, women lack meaningful autonomy or choice. However, because of our judiciary that relies strictly on traditional culpability, it overlooks prolonged trauma, causing secondary victimization where survivors are further penalized by a formalistic legal system and societal stigma. To dismantle this punitive model and move towards a transformative jurisprudence, we have few recommendations that would be given by our next presenter, Jestha. Thank you very much.
Good morning, everyone. Building upon the insightful discussion presented by my co-author Susmita, I will now briefly highlight the policy implications, recommendations, and conclusion part of our research and presentations. Our study shows that survival-driven crime committed by women cannot be understood only through a traditional criminal law framework. Rather, it requires a deeper examination of the social, economic, and gender-based realities that often shapes women's pathway into criminal behavior. First, there is an urgent need for a gender-sensitive approach within criminology and the criminal justice system. Traditional theories of criminology have largely been developed around male experiences and often fails to capture the unique challenges faced by women. Understanding the role of poverty, abuse, discrimination, and social expectations is essential for delivering meaningful justice. Second, in cases involving survival-driven crime, the justice system should prioritize rehabilitation over punitive approach. Greater focus should be placed a non-custodial alternative such as rehabilitation, community service, restorative justice, and diversion programs. These approaches recognize hardship while still maintaining accountability and rule of law. Third, policymakers must shift their focuses from punitive response to preventive measures, addressing root causes such as poverty, economic dependency, lack of education, and furthermore. Trauma-informed justice system is equally important. Police officers, prosecutors, lawyers, and judges should be equipped to recognize the impact of prolonged abuse and trauma on women's actions. At the same time, prisons and co-relational policies will provide mental health support, skill development opportunities, and effective reintegration mechanism to all the victims and the survivors. Our research also highlights the need to strengthen domestic violence protection mechanism, promote gender-sensitive law enforcement practice, and reform sentencing law so that survival-based circumstances are clearly recognized as a mitigating factor in our Muluki criminal code and other legal system. In conclusion, the concept of survival crime invites us to rethink criminal law through a more human and contextual lens. It reminds us that while crime remains legally unacceptable, not every crime emerges from the same circumstances. Some acts are rooted in necessity, vulnerability, and systematic inequality. At the same time, we would like to clearly emphasize that this presentation does not seek to justify or legitimate any criminal act committed under the claim of survival. Crime in any form remains unlawful and cannot be excused. Rather, our intention is to highlight the importance of understanding context so that the justice system can respond in a fair, proportionate, and informed manner. Therefore, justice should not be measured only by the severity of punishment, but also by our ability to understand the conditions that give rise to offending behavior. Recognizing survival-driven circumstances does not weaken the justice system, rather it strengthens it by making it more fair, responsive, and equitable. Thank you so much.
Thank you, President. अब हामी अर्को प्रेजेन्टेसनको लागि अनुरोध गर्छौँ। सुरक्षा बराल So they will present on the topic reproductive autonomy and infanticide in Nepal, a feminist critics on the criminal liability under the Muluki criminal code.
Hello, check. Mic check. Good afternoon, everyone. My name is Jestha. I, alongside my co-presenter Kripa Himre, will be presenting our paper on the topic Reproductive Autonomy and Infanticide in Nepal, a feminist critique on criminal liability under Muluki Criminal Code. Under this, we have two major objectives: to analyze the social legal nexus between the erosion of reproductive autonomy and the commission of infanticide under Muluki Criminal Code, and to interrogate about jurisprudential failure of legislation which my co-author will be defending. Now, in order to understand about our paper, we need to understand what reproductive autonomy is. Reproductive autonomy is a woman's ability to have informed choices about her own body and reproductive rights. It means to grant to a woman power over their body, their sexuality, their health, their relationships, and if, when, and whom to partner, marry, and have children with without any kind of coercions or forcefulness. Infanticide, on the other hand, is a deliberate act of killing a child, usually under the age of 1. And this is criminalized under Section 184 of Muluki Criminal Code in our country. Now, a crime as heinous as infanticide cannot be looked upon as an individual act of force. It is rather a very profound conclusion of a structural coercion in our society. Now, structural coercion is a broader concept of coercion. It includes social, economic, and political contexts, and it compels an individual to act a certain way in the society. Now, under this falls reproductive coercion, and it is a hidden and a much more intense form of violence against women. It involves behavior of control by families or partner of a woman, and that means they have the power to choose either to promote or prevent a pregnancy in women. Now, where does this constraint of reproductive autonomy comes from? Male-centric norms in our society is usually the major cause. Man of the society is considered the head of the family, and usually they have the power to make all kinds of decisions, which means they also have the power to make decisions over a woman's body, and it is always rooted upon a lower social status, illiteracy, and economic dependency upon a man, because usually women are not given the choice to have financial freedom in our society. Many Nepalese women remain silent about violence and coercion due to social, economic, and political factors, and long-term psychological trauma that comes because of remaining silent for so long creates an extreme outburst inside a woman's mental health, and that creates such crimes such as infanticide. Especially in marginalized women, more vulnerable in sexual abuse, unwanted pregnancies, and denial of reproductive rights due to discrimination and poverty and lack of awareness can also result into infanticide. Nepal's constitution protects reproductive rights under Article 38 of Constitution of Nepal. We also have Safe Motherhood and Reproductive Health Rights Act 2018, and we also have landmark cases like the case of Lakshmi Devi Dikta. However, having all of this, despite having such strong laws and such strong precedents established in our country, the access remains very limited, especially in rural areas, due to inadequate healthcare facilities, lack of awareness, and most importantly, geographical barriers. As of a report of 2021, only 19.2% of health facilities provide abortion services. As of 62% of unintended pregnancies result into abortion, which more than 58% of abortions are illegally done. And the geographical isolation, the transportation cost, also causes women to not have choices in making a safe abortion and using their rights. Women from poor households, as per research, are 2.16 times more likely to have abortions which are unsafe. Dalit women are 1.8 times more likely, and people, especially women who are unaware about safe abortions, are 5.13% have 5.13% more chances of inducing into unsafe abortions. A report of UN Women shows that 53% of people are only able to access contraceptives in our country, and women whose contraceptive needs are unmet are 14 times more likely to indulge into unwanted pregnancies and resulting it into unsafe abortion as well. Now, where does this come from? Where is this psycho-legal relationship between denied reproductive rights and infanticide in Nepal takes us to? Well, feminist perspective, if we look through it, infanticide is rarely an act of free choice, especially among women, because it is an outcome of structural prevalence in our society. Limited access to contraception, abortion services, a legal system that focuses mainly upon punishment rather than rehabilitation and looking to underlying causes is three of the major causes. Nearly half of the pregnancies, sometimes they result into unwanted abortions. 2/3 of unwanted pregnancies result into abortions, and in the last 4 years, abortion rates have increased to 31%. Unintended pregnancies are very closely linked to violence because 27% of Nepalese women are subject to physical and sexual violence by their partners. Now, intimate partners violence, IVP, is 2.5 times more likely to develop mental health issues among women. And all these mental suppressions, these mental health issues, psychological trauma usually leads into 3.5 more chances of postpartum depression. and denial of such reproductive rights eventually leads into having such kinds of mental health issues and turning it into an increased risk of infanticide. And one of the causes is this. However, the next cause is also jurisprudential failure, which will be defended by my co-presenter, Kripa. This is my time. Thank you so much.
Hello. Having established the relationship between reproductive autonomy and newborn death cases, I now turn to the second objective of our paper. Section 184 primarily addresses abandonment and neglect, while also imposing legal duty of care on the person responsible for providing such care. However, Section 184, subsection 3, performs a much more consequential function, where the abandonment or legal results in the death of a newborn. Section 184, subsection 3 directs the case to Section 177, Nepal's general homicide provision. The question raised by our paper is therefore not whether newborn death should be punished. The question is whether newborn death cases arising from abandonment, neglect, vulnerability, reproductive crisis should automatically enter the ordinary homicide framework without legislative recognition of its distinctive context. Our analysis suggests that the current framework does not adequately address that question. Next. The problem is not merely that the law is harsh. As demonstrated in the first part, cases often emerge from an intersectionality involving reproductive crisis, adolescence, vulnerability, social stigma, reproductive coercion, poverty, and abandonment. Yet, Section 184.3 does not expressly recognize this reality before directing cases involving death to Section 177. The problem is not merely that the law is harsh. The problem is that the law no longer reflects the reality it seeks to resolve. There are three major reasons of stating jurisprudential failure. Number one, failure of culpability. The first jurisprudential failure is, as said by Hart and Becerra, remind us that criminal liability must reflect blameworthiness and punishment must reflect proportionality. Yet, Section 184.3 provides no distinct framework for assessing the unique circumstances that often surround newborn death cases before directing them to Section 177. Next is failure of social responsiveness. Pound and Savagny argued that law must evolve alongside and respond to lived realities. However, social structure factors remain largely invisible in the operation of Section 184.3. Third factor is constitutional morality. Dr. Ambedkar has highlighted that constitutional governance requires dignity, equality, and substantive justice. Yet Section 184 largely responds to the outcome of death rather than the context in which that outcome occurs, creating tension between criminal liability and constitutional values. Next. Let's move and have a look at this Supreme Court decision, decision number 11082. What happens in this case is quite interesting. Court did not look at the case of homicide, infanticide perhaps, as just as offense. It also looked at the circumstances surrounding it, adolescents' vulnerability, reproductive realities, and the possibility of rehabilitation. The court ultimately held that minimum punishment was sufficient. Next. So why is that important? Because the court was doing more than deciding a case. It was filling a gap. It considered factors that Section 184.3 does not expressly tell us how to consider. And when judges repeatedly have to do that, it raises an important question. Should those distinctions come from judicial discretion, or should the law itself recognize them? Next. Talking about feminist jurisprudence, which is the crucial aspect of our paper, is that dimension intersectionality that needs to be acknowledged. It reminds us that equality is not achieved by ignoring context. To understand these cases, we must look beyond the final act and consider realities that often precede it. Next. Perhaps the strongest validation that concerns and reaffirms our claim so far is the Criminal Justice Administrative Task Force Reform Review that was published in 2081 by the Attorney General's Office, which states that after reviewing the provision of 184.3, it recommended amendment recognizing the disproportionate impact on vulnerable women. Now we move towards the recommendation aspect. Recommendation number 1, previous slide please. While the provision begins as one addressing abandonment and neglect, subsection 3 ultimately directs cases involving death to section 177. The law should recognize the distinctive context of newborn death cases before treating them to the ordinary homicide framework. Second is that we would provide court with more appropriate framework for addressing newborn death cases than ordinary homicide law. For example, there are rules and provisions act from England, UK, Australia, which we can use as a guiding mapper. Ultimately, our argument is not that newborn life deserves less protection. We argue that criminal law should distinguish between deliberate murder from newborn death arising within conditions of profound vulnerability. The question is whether this transition is adequately reflecting the realities of our community. We suggest the current scenario, the current act is not, and it requires immediate changes. Thank you.
Thank you, presenter. Now I'd like to call next presenter, Anis Adhikari, Subesh Fiyan, on the topic prostitution, a crime, a profession, or an economic activity in Nepal.
Good morning, everyone. My name is Subesh Fiyan. Alongside my friend Anis Adhikari, we are presenting our conference paper titled Prostitution of Crime, Occupation, or an Economic Activities in Nepal. This paper sits at the intersection of law, economics, and social justice, and we hope it provokes a meaningful discussion today. I will cover the first half, and Anis will take remaining other part in second half. Let us begin with context. Across societies, certain activities are openly regulated, others remain hidden, contested, and morally debated. Prostitution falls firmly in the latter category. It is one of the most controversial social and legal issues worldwide, defined simply as the exchange of sexual service for money and goods. The word itself comes from the Latin prostitute, meaning to expose publicly, which has never been a private issue. It has always lived in public eye and with its centuries of stigma. Prostitution is an organized profession which is recent time is also known as the sex work. It is recognized as one of the oldest professions in the world, which is rooted in the centuries of practice from ancient time to till now. By the movement 2007 and 18 agreement with Nepal government, which talks about the basic right of Badi Women Committee. Women. So, what is the core problem we are examining? Nepal criminalized soliciting, running brothels, and promoting prostitution. Yet, prostitution continues to exist both visibly and in hidden form. This raises a fundamental question: does criminalization eradicate the practice, or does it simply push it underground into more dangerous conditions? And underneath the legal question lies a deeper one: the role of poverty, gender inequality, and caste discrimination has driven the lead individuals into prostitution in the first phase. Next slide. Our study is guided by 3 research questions. First, should prostitution be treated as a criminal offense or recognized profession or a formal economic activity? Second, does criminalization effectively reduce prostitution or merely driven it underground? Or how do socio-economic factors like poverty, gender inequality, and caste discrimination shape individuals' involvement in Nepal? These 3 questions frame everything that follows. Next. Before proceeding, I want to briefly acknowledge our study limitations. We were unable to obtain official statistics through the Right to Information (RTI) process, and accessing primary field data was significantly constrained as expected due to the sensitive nature of the subject, social stigma, legal restrictions, and the hidden reality of the practice. The limitations are themselves of finding transparency matters even when data is scarce. These are the literature review on this paper. First, Scott et al. 2021 found that the public tolerance of sex industry depends not on its legal status but on perceptions of worker safety and autonomy. Next is Sarma. This research is conducted by the Bhavana Sarma in 2021, whose title is Position in India, a critical analysis. Identifies poverty, the Deldasi systems, and cybercrime as key drivers, and recommendation legalizations paired with right-based rehabilitations. Another is Tarajan Gurung and Sandeep Lloyd concept 2016 article that women exclusion from property rights and formal employment narrows their options, increasing vulnerability to exploitations. Another is Money Man Singh Raj Bhandari 2020 takes a more cautionary view, pointing to unemployment using money and organized syndicates as force that makes the sex trade harmful. Taken together, the literature is divided, which is precisely why this paper exists. Next slide. Methodology. Our methodology is mixed methodology. On the qualitative side, legal provisions, case law analysis, scholarly articles, and policy documents. On the quantitative side, annual reports, governmental publications, and data from the Office of Attorney General and district attorney records. For the presentation, I would like to call my friend Ansari Gari.
Okay, thank you. It's me, Ansari Gari, and now I will continue with the further presentations. And I will start from the data. This is the data we got from the Office of Attorney General. If you see the data of Office of Attorney General, no cases were registered, prosecuted, or disposed in the fiscal year 2081, 82, 2080, 81, 2078, 79, 2077, 78. Only in the fiscal year 2079 and 84 cases were recorded. However, none of the cases, no one is convicted or acquitted. Next slide. And Office of High Attorney Generals. This is the data we got from Office of High Attorney. As per these tables, 3 cases were registered in the fiscal year 2081 and 82, and none of the cases were finalized leading to conviction. One was acquitted, one was forfeited, and 2 were left pending. Similarly, in 2018-81, 2 cases were registered, but none was the convicted or disposed of. So, So these two cases are still pending. There was one case in 2017 and 18 which was acquitted. There was no pending case. In the previous year, the same trend is observed. 2 cases were registered in 2017 and without any conviction or disposal, all pending trial. 4 cases in 2017, 1 acquitted and 1 case disposed of, all pending trial. Next. And District Attorney Office. Okay, to make the best uses of our time, I will proceed straight to the analytical findings of this data. Next. If we see the overall trend of this data as per the data we got from Office of Attorney General, the trend remains low registration of case, high percentage of pending case, and inconsistency judicial review. Next. Okay, international legal standards. The Convention on the Elimination of All Forms of Discrimination Against Women and Convention on the Right of Child talks about the prostitutions. And the domestic law, though we don't have a direct act of status to regulate the prostitution, however, we do have a constitution of Nepal which ensures the socio-economic justice for women under the fundamental right and other constitutional provisions such as every person shall have right to live with dignity, equality before law, and every person shall have right to freedom to practice any professions, career, any occupations, and establish and operate any industries, trade, business, and in any part of Nepal. And we do have a national penal code. Though it does not explicitly mention prostitution is criminalized, but indirectly indirectly criminalization model. It provides provision under Section 119, which include provision of soliciting the prostitution, and if someone they will be liable up to 3 years of imprisonment and up to 30,000 of fine. And Section 120 is prohibited of providing house, land to be used for prostitution or sexual intercourse with prostitution. And if someone commits such act, they will be liable for up to 6 months of imprisonment and up to 5,000 of fine. Next, please. And we do have a Human Trafficking and Transportation Control Act. Human Trafficking and Transportation Act define victim means a person who is sold or transported or put into the prostitution. As for the Section 15, any persons who commit an offense, they will be liable for imprisonment for in a term of for forcing someone into prostitution with or without financial benefit. They will be liable for 5 to 10 years of imprisonment and 50K to 100K to fine. And if someone engaged in prostitutions, they will be liable for 1 month to 3 months with 2,000 rupees to 5,000 rupees of fine. So I will take just 2 minute additional time to conclude my presentations, please. Please. Okay. Okay. This is the judicial interpretation and its contributions. Ganu Devi Rana versus Ministry of Government. This NK 2075. Decision number 9914. Decision number 7571. Decision number 10617. They all talks about after trafficking, forcing someone into the prostitution is a heinous crime. While Sapana Pradhan Malla versus His Ministry of Government's filed repetitions, they advocate about sex work constitutes a form of profession or occupation. That is not a crime, that is also the professions. But this is the legal gap analysis. Any laws cannot define what is prostitution, so that they indirectly criminalize the prostitutions. And we do have and court really distinguishes between volunteer forced participation in prostitutions. We do and there is a poor rehabilitation systems and misapplied public decays laws are the major legal gaps that we found. Prostitution, as per our law, prostitution is considered as a crime and directly or indirectly, all of the countries from South Asia recognize prostitution as a crime. If we see the data from, if we see the data, legal status of prostitution around the world, 43% of countries, which means among 162 countries of the world, it is prohibited 69 countries. It is prohibited in 69 countries, which is 43 of total countries. Limited legal in 39 countries, which is 23% of, whereas legal in 54 countries, which is 34% of total country, and estimated that 42 million people engage in prostitution worldwide. And next slide, please. And this is the concept of Nordic model that we know. We incorporate in our paper. It talks about it talks about like sex worker themselves is not a criminal, they are the victim. Those who go for sex or that profession, they are the they are the perpetrator. It means our Nepal legal framework is also like that. The sex worker themselves is not mentioned as offender side. Provide properties. Next, please. And if we talks about prostitution as a professional economic act in Nepal, Germany, New Zealand, and Netherlands, they allowed prostitution as a legal business while treating sex worker as employment protected under standard health, safety, and human rights law rather than punishment. But Nepal laws criminalize the prostitution. It still happens as underground crime. Next, please. Okay, as we know, at 2007 there is a movement from Badi community, but government they signed a 20-point agreement with the government. Government aid to provide other jobs prosecuted for Badi's sex worker, but it is not implemented. Next, please. Okay, so what are the socio-economic factors that makes people to get into prostitution? So first factor is family practice and intergenerational transmission. We got the cases of Kalpana Badi. She was introduced to sex worker by her own mother at the age of 16, which shows how prostitution can be normalized within certain families' environment due to the long-term economic deprivation and social exclusion. Next is poverty. Poverty is one of the most significant structural factors pushing individuals into the prostitution in Nepal. The cases of Rekha clearly demonstrated how financial hardships, lack of social protection, and absence of alternative livelihood opportunities can lead to involvement in the sex work. Another factor is the lack of employment opportunities. The same case, Rekha illustrated that after separating from her husband, she migrated to the Kathmandu seeking work, but she is unable to find any stable employment. So she saw no alternatives, highlights that prostitution in such case is not necessarily a freely chosen profession but a response to economic deprivation. And gender-based economic inclusion, economic vulnerability, and income instituted other factors, and human trafficking is also one of the most serious factor leading to the prostitution in Nepal. Recently, Mighty Nepal's internal rescue operation freed another 520 survivors from various locations across the Nepal, primarily within the adult entertainment sectors. And what are the consequences of prostitution? If we see the consequences of prostitution in Nepal, data from our 2025 report submitted to the CEDA committee reveals that 25% of reported violence cases against sex workers in Nepal were perpetrated by police themselves, with another 50% involving anti-trafficking NGOs. Public health crisis, HIV/AIDS violence. While Nepal can make progress in the HIV treatment access, but still, female sex worker 1.5% contribute to the increased HIV/AIDS in Nepal. Citizenship deprivation. Although the government of Nepal signed 28-point agreement with National Badi's Right Struggle Committees, which also include the certain commitments such as providing citizenships, properties right, but still 63% of sex workers who are related to that profession, historically that profession, or belong from that community, they don't have a citizenship. Without citizenship, they cannot vote, they cannot open the bank account, they cannot access any government welfare programs or enroll their children in the school. Another consequence is psychological and social consequences, stigma and isolations. The stigma is so profound that many return and women hide their sex worker experience indefinitely, and legal and judicial consequences. Between 2020 to 2024, over 55 sex workers were forcibly taken so-called rescue home by anti-trafficking NGOs, often without their consent and under conditions amounting to the false imprisonment. Okay, next slide, please. Okay, and so next slide.
I think we should conclude.
Okay, sir. Okay, so conclusion. Okay, now conclusion. The current legal framework which criminalizes solicitations, brothel keeping, and third parties involvement. Our laws leading the act of selling sex itself is legal ambiguity has failed to achieve its standard objectives. The criminalization's model has proven ineffective and counterproductive, as evidenced by the displacement of sex workers into unregulated space, private homes, cabin, restaurant, digital platforms, and also the evidence the consistency of street-based sex workers, the shift of digital platforms such as using the Facebook, WhatsApp, digital apps as the paper has identified as a critical legal gap that confirms the legal provision does not eradicate the practice. And the case of Kamlabad is illustrated that the sex work within the marginalized case revealed that entry into sex work is really a free choice but a survival mechanism shaped by the deep-rooted socio-economic factors, poverty, lack of employment, and so on. And please, next slide. So recommendations. So our first recommendation is required first resolve the current legal ambiguity by defining what constitutes prostitution as a crime. And second is the government must expand social protections program by establishing targeting livelihood funds, vocational training, and income generating opportunity for the women at risk, especially those from the marginalized communities historically associated with sex work. And third is ensuring equal pay, access to property rights, and economic inclusion is essential to reduce dependency on exploitative systems. Okay, and last, adopt a right-based approach. Thank you.
Thank you, presenter. अब हामी अन्ततिर प्रेजेन्टेसनको अन्त्यतिर आइपुगेका छौँ र अन्तिम प्रेजेन्टेसनको लागि चाहिँ निस्मा बल्लामा स्वस्तिका राई उहाँलाई प्रेजेन्टेसनको लागि म अनुरोध गर्छु। Start.
Good afternoon, everyone. Respected session chair Rajaram Dwal sir, fellow researchers and participants. My name is Nisma Rama, and I am here with my co-author Swastika Rai. Today we are presenting our research on economic deprivation and female criminality in Nepal's marginalized communities, a judicial records analysis. This study looks at whether economic hardship directly pushes women from marginalized communities into crime. Let's start with the context. In Nepal, crime is usually seen as a male issue. Most laws and studies focus on men as offenders and women as victims. For instance, we can take section 219 of Unity Criminal Code 2074, which defines rape as an act where a man has sexual intercourse with a woman without her consent or with a female below the age of 18. This shows a male-centered legal framing where men are assumed as perpetrators and women are only positioned as victims. According to many criminological research, women follow different crime paths than men, usually because of structural inequalities and socioeconomic conditions, which also denotes a gradual rise of women's involvement in criminal activities. Marginalized communities in Nepal represents socially and economically disadvantaged groups that have been excluded from access to resources, opportunities, and decision-making processes for a long period of time. In Nepal, most studies treat women only as victims of crime. There is a very limited research on women as offenders and almost no empirical study on the link between economic deprivation and female criminality in marginalized community. which is our major research gap. Our research question is, what role does economic deprivation play in shaping female criminality within marginalized communities in Nepal? Our objective was to see if economic deprivation plays as a direct determinant, or whether it plays as an indirect determinant in shaping female criminality within the marginalized communities of Nepal. To understand this issue, we used two important theories. First theory is strain theory. This theory says that when people cannot achieve socially accepted goals like having money or job or a good life through legal means, they feel pressure or a strain. And some may follow illegal ways to survive, succeed, or achieve these socially accepted goals. Next theory is feminist criminology. Women face, according to this theory, women face multiple layers of disadvantage, and women's involvement in crime cannot be understood without looking at the layered disadvantages like gender inequality, class, caste, and social exclusion. So these two theories best align with our research. For the methodology, we adopted a descriptive and analytical approach. The main source of data was judicial decisions published in NKP from fiscal years 2072 to 2082. We used purposive sampling, which is also a type of non-probability sampling method. This means that we did not select cases randomly. Instead, we deliberately selected cases, chose only those cases that involved female offenders from marginalized communities. We selected cases based on indicators like caste, socioeconomic background, or any mention of vulnerability in the court's judgment. In the limitation, so our study has several limitations. It relies on judicial data that often lacked detailed socioeconomic information. We used purposive sampling, which limits how far we can generalize the findings. Mainly, our research include reported cases, meaning many unreported cases or cases or crimes are not captured in our study or remain outside the scope of this research. We initially intended to do an age-based analysis, but due to inconsistent recordings of the age information, we were not able to do it. So our key findings. So as feminist criminology suggests, in order to truly understand women's involvement in crime, we must first examine the structural context in which they live. Factors such as caste, gender, class, and social exclusion play a crucial role in shaping women's opportunities and vulnerabilities. Therefore, before analyzing, we extracted these data from credible sources like Central Bureau of Statistics, Nepal Living Standards Survey, Nepal Flash Report, Nepal Country Inequality Reports. And therefore, before analyzing the criminal cases, we examined credible data from these sources. The data clearly shows significant structural disparities in marginalized communities, particularly in education, employment, wages, and food security. These conditions increases vulnerability for women from these communities. So for our key findings, we analyzed criminal cases published in NKP, Nepal Kanun Patrika, over 10-year period from 2072 to 2082. We examined cases involving women both as perpetrators and as victims to get a broader picture. Out of the total 328 criminal cases that involved women, we found 86 cases where women were acting as perpetrators. Among these 86 cases, 38 cases involved women from marginalized communities. We found out that 6 cases were directly linked to financial gain, whereas we only found one case that was directly linked or explicitly linked to economic deprivation, where a woman committed crime solely because of economic deprivation, or it was a major reason behind the crime. And as we can see, these are the offense types, or the types of offense in which women from marginalized communities these are the crimes that were committed by women from marginalized communities. Narcotic drug, we found that two cases, kidnapping 1, forgery 3, fraud 3, trafficking 7, and homicide 16. Thank you. I would like to hand over this presentation to my co-author.
Good afternoon everyone, respected session chair and fellow researcher and participants. My name is Jestha and I will be continuing this further presentation where I will be discussing about the analysis, discussion and policy recommendation and conclusion of our study. So for the conclusion part, this study has examined the cases reported in NKB from fiscal year 2072 to 2082 involving the female offenders from the marginalized community. So our aim is to see if the economic deprivation appears as an indirect or direct influencing factors of the female criminality. Whereas the finding shows that women from the marginalized communities were involved in the various offenses like homicide, human trafficking, forgery, kidnapping, and financially motivated crimes. And our finding doesn't support economic deprivation as a direct cause of female offending. So among the cases we have reviewed, only one cases explicitly identified economic deprivation as an immediate motivating factor, and in contrast, several cases were linked with financial gain, and while others are always with the personal conflict, family dispute, coercion, and the situational circumstances. So the case of Ramagali Chaudhary versus Government of Nepal, in this case, the accused was living in the severe poverty and the social vulnerability, where the court reduced the sentence after acknowledging the impact of economic hardship, psychological distress, and the social vulnerability. So this case indicate that economic deprivation may contribute criminal conduct in some exceptional circumstances, but it doesn't emerge as a common direct cause. So for a discussion part, the study shows that economic deprivation is not usually recorded as a direct cause, rather it is interconnected with the social and structural factor. So in most of the case reviewed, crimes are linked with the family conflict, coercion, abuse, personal relationship, lack of education, social exclusion, economic dependency, and economic hardship seems to increase vulnerability rather than directly causes crime. So the findings also partially question the strength theory and the strongly aligns with the female criminology, whereas the strength theory suggested economic pressure directly leads an individuals to commit a crime when legitimate opportunities are blocked, whereas female criminology emphasized that women pathways into crimes are set by their intersecting inequalities such as gender discrimination, caste-based exclusion, poverty, and the social dependence. So this is why female criminality in marginalized community should be understood not as a direct outcome of a poverty, rather it is a combined result of structural inequality, social vulnerability, and the situational pressure. Sir, could you extend my time? Thank you. Now for the policy recommendation, here are some policies that we have studied, we have written in our research paper. So the first one is we have to improve the educational and vocational training for the marginalized women so they can economically independent. And the next one is strengthening employment and income generation programs, especially targeting the economically vulnerable women so they have the stable income. And likewise, in third point, expanding and access to legal aid, counseling, and rehabilitation centers for the female offenders. Likewise, in fourth point, developing gender-sensitive rehabilitation policies within a correctional institution. And the most important recommendation is improving judicial record keeping by including socio-economic background and information of the offender. Likewise, the last one is encouraging further empirical research on female criminality and structural inequalities in Nepal. So for the conclusion part, economic deprivation doesn't emerge as a direct cause of a female criminality in Nepal marginalized communities, but only 1 out of 38 cases explicitly cited about the economic deprivation. and the women of the marginalized communities were involved in the various crime, but out of them, homicide and human trafficking were more frequent than accepted. And the findings challenges that assumption that women were committee of the minor offense, and the key limitations is age-based analysis cannot be conducted due to the inconsistent judicial record. So overall, female criminality is better explained through the structural inequalities rather than the poverty alone. Thank you.
अर्को सेसनमा चाहिँ हाम्रो 20 मिनटको समय क्वेसन एन्सरको लागि आउँछ। 20 मिनटमा क्वेसन एन्सर सेसन सक्ने पश्चात त्यसपछिको सेसन सियरलाई ह्यान्डओभर हुनेछ र तपाईँहरूको प्रेजेन्टेसनमाथि सियरलाई कमेन्ट गर्नुहुनेछ। त्यसभन्दा पछि हामी अन्तिम सेसनमा प्रेजेन्टरलाई सर्टिफिकेट डिस्ट्रिब्युसन र सियरलाई टोकन नम्बर डिस्ट्रिब्युसन प्रोग्राम भएको छ। त्यो समापन पश्चात चाहिँ 1 घन्टाको समय हाम्रो लन्च ब्रेक छ। यो सबै सक्यो भन्दापछि हाम्रो स्टार्टिङ फेजमा जहाँ ब्रेकफास्ट भएको थियो सोही ठाउँमा चाहिँ लन्चको लागि प्रस्थान भइदिनु होला। अर्को सेसनमा चाहिँ क्वेसन एन्सरका लागि हामी अगाडि बढ्न गइरहेका छौँ। क्वेसन एन्सर गर्दाखेरि तपाईँहरूले कुन प्रेजेन्टरलाई चाहिँ कति नम्बरको प्रेजेन्टरलाई प्रश्न सोध्नु भएको त्यो समेत उल्लेख गरेर प्रश्न सोधिदिनु होला। अब प्रश्न एउटा क्वेसन एउटा उत्तर भन्दाखेरि पहिला प्रश्न लिउँ, त्यही अनुसार चाहिँ त्यो सेसन जसरी हामीले पेपर प्रेजेन्टर गरेका छौँ त्यसरी 1 2 3 4 5 मा चाहिँ क्वेसनहरू आउनेछन् भन्ने र अब तपाईँहरूको क्वेसन के छ प्रेजेन्टरहरूलाई चाहिँ सोध्न सक्नुहुन्छ। यो माइक युज गर्न सक्नुहुन्छ।
एउटा क्वेसन एन्सर सेसन भयो। अर्को चाहिँ तपाईँहरूसँग क्वेसन छैन बट यु हेभ अ ओपिनियन है अन दिस टपिक। तपाईँहरूसँग चाहिँ आज हामीले जुन प्रेजेन्टेसनमा प्रेजेन्ट गरियो जुन टपिकहरूमा क्वेसन छैन बट यु हेभ अ ओपिनियन अन द्याट टपिक है छ भने पनि यु क्यान अल्सो सेयर अन दिस सेक्सन।
माइक प्रयोग गर्न सक्नुहुन्छ।
आजको हामीले यहाँ 5 वटा टपिकहरूमा प्रेजेन्टेसन गर्दै गर्दाखेरि तपाईँहरूलाई लाग्दो 5 वटा इन्टरकनेक्टेड पनि छ। सो एउटा प्रेजेन्टेसन ग्रुपको प्रेजेन्टरहरूले पनि अरू प्रेजेन्टेसन जुन टपिकहरूमा छ उहाँहरूको आफ्नो ओपिनियन यसरी चाहिँ बुझ्नुपर्छ अथवा यसरी गर्दाखेरि भन्ने तरिकाले पनि अगाडि बढ्न सक्नुहुन्छ है।
थ्याङ्क यू सर। मेरो नाम प्रतिष्ठा ढकाल, म काठमाडौँ स्कुल अफ ल BLLB 4th इयरमा अहिले अध्ययनरत छु। हाम्रो चाहिँ एज इन अब सर्भाइभल क्राइम भएर उहाँहरूको प्रेजेन्टेसन जुन प्रस्टिट्युसन भन्नुभयो, त्यसपछि इन्फेन्टिसाइडको कुरा आयो, उहाँहरूले पनि इन्फेन्टिसाइडको कुरा आयो, त्यसपछि मार्जिनलाइजेसनको कुराहरूबाट उहाँहरूबाट आइसकेपछि चाहिँ यहाँनिर चाहिँ एज इन सर्भाइभल क्राइम भनिसकेपछि एउटा महिलाले सर्भाइभ गर्नको लागि उसलाई सोसाइटीमा जुन साहित्यहरूले मेन्सन गरेको थियो लो क्लासको कुरा, उसले मेन्सन गरेको थियो लो क्लासको कुरा। लो क्लासको कुराले गर्दाखेरि मैले एउटा केस के पढाएको थिएँ भन्दाखेरि एउटा खुस्मा भन्ने एउटा केस, त्यसमा चाहिँ के थियो भन्दाखेरि 16 कि 17 वर्षको एउटा युवतीले चाहिँ के गरिन् भन्दाखेरि उसलाई रेप भयो अनि उसले चाहिँ बाँच्नको लागि वा सोसाइटीको लो क्लासबाट चाहिँ उनी बाँच्नको लागि मात्रै उसले के गरिन् भन्दाखेरि इन्फेन्टिसाइड गर्न चाहिँ उनी बाध्य भइन्। अनि त्यसपछि अर्को धौली देवीको केसमा पनि त्यस्तै वाला उनी इन्फेन्टिसाइड गर्न बाध्य भइन्। अनि त्यसपछि यता प्रस्टिट्युसनको कुरा आउँदाखेरि अघि सुस्मिताले भने जस्तै वादी कम्युनिटीमा चाहिँ के भइरहेको छ भन्दाखेरि उनीहरूलाई चाहिँ एज इन अगाडि चाहिँ गीतहरू गाउने, बाजाहरू बजाउने भनेर भनिएको थियो। तर त्यसले मात्र उनीहरूलाई चाहिँ जीवनयापन गर्न सर्भाइभै गर्नको लागि नपुगेका
कारण चाहिँ उनीहरू एज एन अहिले पनि त छन् नि त त्यो उसमा इन्भल्भ भइरहेका छन्। अनि अर्को कुरा भनेको हामी एलजिबिटिक्यू राइट्सको कुरा गर्छौँ, यो भन्छौँ त्यो भन्छौँ, तर एलजिबिटिक्यू राइट्सको कुरा गरिरहँदा चाहिँ उनीहरूलाई सिस्टम नेपालको अब कुनै पनि रोजगारीको कुरा होस् या अब जे अपर्च्युनिटिजहरू छन् कुनै अफिसमा गयो भने त्यही कारणले मात्र उनीहरूलाई रोजगारी नदिने, जसको कारणले गर्दाखेरि उनीहरू सर्भाइभलकै लागि एज एन बेगरको रूपमा काम गरिरहेका छन् नि त। अब यो एज एन यो इन्टरकनेक्टेड कुरालाई चाहिँ मैले क्वेसन भन्दा पनि यसलाई चाहिँ हामीले कसरी एज एन मिटिगेटिङ फ्याक्टरको रूपमा चाहिँ दिन सक्छौँ? हाम्रो मुलुकी क्रिमिनल कोडलाई नै एज एन अमेन्ड गर्नुपर्ने हो कि एज एन सर्भाइभल क्राइमलाई नै हामीले मुलुकी क्रिमिनल कोडमा चाहिँ राख्नुपर्ने हो कि? जस्तै इक्जाम्पलको लागि युकेमा के छ भन्दाखेरि कन्फिडेन्स एन्ड जस्टिस एक्ट 2009ले चाहिँ वहाँनिरको प्रोभोकेसनलाई चाहिँ लस अफ कन्ट्रोल डक्ट्रिनबाट रिप्लेस गरेर इमिडिएट थ्रेट नभए पनि लङ टाइमबाट अब्युजको कुनै एउटा महिला शिकार भइरहेको छ वा कुनै पनि व्यक्ति शिकार भइरहेको छ भने उनीहरूलाई एज एन मिटिगेटिङ फ्याक्टरको रूपमा ल्याउनुपर्छ है भनेर ल एक्ट गरेको छ। यसरी नै नेपालमा पनि एज एन अब हामी एज एन ल स्टुडेन्टले ल मेकर्सहरूले चाहिँ कसरी यसलाई अघि बढाउन सक्छौँ भनेर यो चाहिँ मेरो डिस्कसनको कुरा भयो, क्वेसन भन्दा पनि डिस्कसन लागेको कुरा। थ्याङ्क यू।
अन्य पार्टिसिपेन्टहरूले पनि आजको पेपर प्रेजेन्टेसनको टपिकहरूमा चाहिँ आफ्नो ओपिनियन र क्वेसन्सहरू केही छ भने क्वेसन्सहरू सोध्न सक्नुहुन्छ र आफ्नो ओपिनियन चाहिँ सेयर गर्न सक्नुहुन्छ।
मेरो क्वेसन चाहिँ सुस्मिता खड्का र प्रतिष्ठा ढकालजीलाई, हजुरहरूले सेकेन्डरी भिक्टिमाइजेसन भन्नुभएको थियो, मलाई यो कन्सेप्टमा अलिकति क्ल्यारिटी भएन, बुझाइदिनुहोस्।
सेकेन्डरी भिक्टिमाइजेसन भन्ने बित्तिकै चाहिँ के हुन्छ भन्दाखेरि, थ्याङ्क यू फर द क्वेसन्स फर्स्टमा त। त्यो भनेको चाहिँ के हो भन्दाखेरि एउटा सर्भाइभ गरिरहेको एउटा महिला छ कुनै सोसाइटीमा, म एज इन के गरेँ भन्दाखेरि मेरो हस्बेन्डले, मेरो बिहे त भएको छैन, मेरो हस्बेन्डले के गर्यो मलाई पिटिरहेछ, मलाई दिनकै टर्चर दिइरहेछ, मेन्टल टर्चर दिइरहेछ, मलाई बाँच्नकै लागि चाहिँ म ब्याटर्ड वुमेन सिन्ड्रोम अघि उसले भनेको जस्तै डोमेस्टिक भाइलेन्सहरूको शिकार भइरहेको छु होइन। अनि मैले उसलाई मारिदिएँ अनि मलाई जेल लगियो होइन। अब त्यो जेलमा म बसेँ, जेलबाट फर्केर आइसकेपछि पनि मलाई समाजले के भन्छ भन्दाखेरि यसले त आफ्नो श्रीमानलाई, म एज एन ठेट नेपाली भाषा बोल्न चाहे, बोल्न त मिल्छ कि मिल्दैन, यसले तैँले मेरो छोरालाई मारिस् वा तैँले मेरो छोरालाई खाइस्। त्यो भनेको त के भयो भन्दाखेरि आफ्नै ज्यानको कुरालाई दाउमा राखेर उसले एउटा सर्भाइभ गर्नकै लागि मार्यो होइन। तर मार्यो, सोसाइटीमा आइसकेपछि त सोसाइटीले उसलाई रिहेबिलिटेसन गर्नको लागि हेल्प त गर्नुपर्ने होला त, तर सोसाइटीले उसलाई गर्दैन। त्यसपछि समाजले के गर्छ भन्दाखेरि ऊ अन्य क्राइम गर्नको लागि फेरि बाध्य भइरहेको हुन्छ क्या। उनीहरू अन्य काम गर्नको लागि बाध्य भइरहेका हुन्छन्, जसको कारणले गर्दाखेरि उनीहरू एज एन क्रिमिनलको रूपमा पनि भइरहेका हुन्छन्। अनि उनीहरू सर्भाइभलकै लागि एज एन भिक्टिमको रूपमा पनि उनीहरू सेकेन्डरी भिक्टिमाइजेसन भइरहेका हुन्छन् क्या। त्यही कुराको लागि समाजले उनीहरूलाई स्वीकार गरिरहेको छैन नि त नेपाली सोसाइटीले, जसको कारणले गर्दाखेरि चाहिँ उनीहरू त्यही क्राइमको लागि फेरि क्रिमिनल्स हुन्छन्। अनि अन्य कुराहरू सर्भाइभ गर्नकै लागि उनीहरूले चोरी गर्नेहरू हुन्छन्। अब यसलाई चाहिँ हामीले एज इन क्रिमिनलको रूपमा हेर्ने कि भिक्टिमाइजेसनको रूपमा हेर्ने भनेर चाहिँ उनीहरू फेरि सेकेन्डरी भिक्टिमाइजेसनको प्याटर्नमा जान्छन् भनेर चाहिँ हामीले यसरी मेन्सन गर्न खोजेका थियौँ यो प्रेजेन्टेसनमा।
मेरो क्वेसन चाहिँ शुभेच्छा र कृपालाई छ। उहाँहरूले जसले एन्सर गर्दा पनि हुन्छ। उहाँहरूले आफ्नो प्रेजेन्टेसनमा इन्फेन्टिसाइड इज अ फ्री चोइस अमङ वुमेन भनेर भन्नुभएको थियो, त्यो चाहिँ अलिकति इलाबोरेट गरिदिन भन्न चाहन्छु।
Thank you, Khushbu. सुन्नमा केही गल्ती भयो जस्तो छ। मैले इन्फेन्टिसाइड इज फ्री चोइस अमङ वुमेन भन्दाखेरि इन्फेन्टिसाइड इज नट अ फ्री चोइस अमङ वुमेन चाहिँ भनेको थिएँ। कहिले पनि इन्फेन्टिसाइडलाई हामीले इन्डिभिजुअल एक्ट अफ क्राइमको रूपमा चाहिँ हेर्नु हुँदैन, किनकि त्यो एकदम सोसाइटीले बाध्य पारेर एउटा स्टडी पनि छ। मेनली वुमेनमा इन्फेन्टिसाइडको अलमोस्ट सिमिलरै छ, तर मेनली गर्ने इन्फेन्टिसाइड चाहिँ आउट अफ रिभेन्ज अथवा उनीहरूको ठुलो डोमेस्टिक भाइलेन्सको बच्चैदेखि त्यस्तै समाजमा हुर्किआएको देखेर उनले गर्ने was it's actually bounded by a lot of social constraints. So sorry if my features for the first time, but what I meant was it is actually never the features.
Namaste, मेरो नाम शैला थापा। अघि प्रतिष्ठाले निकालेकै कुरामा जस्तै सर्भाइभल क्राइम र प्रिमेडिटेटेड अफेन्समा देयर इज भेरी थिन लाइन होइन। कसरी चाहिँ कुनै पनि अफेन्स सर्भाइभल अफेन्स हो अनि जुन चाहिँ प्रिमेडिटेड इन्टेन्सनल हो भनेर क्याटेगोराइज गर्नको लागि प्लस यसको एभिडेन्सियरी भ्याल्यु हेर्दाखेरि पनि धेरै नै एभिडेन्सियरी भ्याल्यु हुनुपर्छ यो कुरामा। सो अब मिटिगेटिङ फ्याक्टर्समा नै सर्भाइभल क्राइम्सलाई इन्क्लुड गरेर लाइक अब प्रोलङ डोमेस्टिक भाइलेन्सहरू हुन सक्छ होइन। त्यो सबै कुरालाई कोर्टको इन्टरप्रिटेसनमा मात्रै नछोडेर लमा नै हामीले त्यो कुरालाई फ्याक्चुलाइज गर्यौँ भने यसलाई चाहिँ कति मान्छेहरूले मिसयुटिलाइज गर्ने पनि चान्स छ नि त। सो त्यसको बारेमा चाहिँ थोरै
Thank you for the question, Saibya. यसमा चाहिँ अघि हामीले भनेको जस्तै नेपालमा चाहिँ त्यो सम्बन्धी अहिलेसम्म कानुनहरू बनिसकेको छैन होइन। नेपालको कन्टेक्स्टमा हेर्ने हो भने राधिका श्रेष्ठको केसमा चाहिँ फर्स्ट टाइम ब्याटर वुमेन सिन्ड्रोमको कन्सेप्ट आएको थियो, जसमा चाहिँ उसलाई 10 वर्ष मात्र सजाय दियो। उसले चाहिँ के गरेकी थिइन् भन्दा आफ्नै श्रीमानलाई चाहिँ एउटा कोठामा जलाएर मारेकी थिइन्, किनभने उसलाई प्रोलङ डोमेस्टिक अब्युजबाट चाहिँ ऊ भिक्टिम भइरहेको थियो, त्यसले उसलाई मारिन् अनि ऊ एज इन ब्याटर वुमेन सिन्ड्रोमको डिफेन्स पाइन्। नेपालमा अरू कन्सेप्टहरू हेर्ने हो भने मुलुकी क्रिमिनल कोडले एज इन प्राइभेट डिफेन्सको रूपमा सेक्सन 22 मा सेक्सन 24 मा त्यसपछि 26 मा डिफेन्स अफ च्यास्टिटीको कुरा गरेको छ, एज इन 39 मा चाहिँ के को कुरा गरेको छ भन्दाखेरि के क्राइमहरूमा चाहिँ मिटिगेटिङ फ्याक्टर हुन्छ भन्ने कुराहरू पेनल कोडले गरिरहेको अवस्था छ। अब यसलाई चाहिँ हामीले अब के छ भन्दाखेरि एउटा राधिका श्रेष्ठको केसमा पनि सुप्रिम कोर्टले के गर्यो भन्दाखेरि डाइरेक्ट अर्डर दियो कि नेपाल सरकारलाई मन्त्री परिषदको कार्यालय चाहिँ ब्याटर वुमेन सिन्ड्रोमसँग रिलेटेड यस्तो क्राइम हुन्छ, त्यही भएर योसँग रिलेटेड चाहिँ एउटा छुट्टै लज बनाऊ है भनेर भन्यो। तर अहिलेसम्म नेपालमा चाहिँ त्यो कार्यान्वयन हुन सकेको छैन, किनभने नेपालको अवस्थालाई सोसियोलोजिकल फ्याक्टर्सलाई हेर्ने हो भने चाहिँ नेपालमा चाहिँ के छ भन्दाखेरि यस्तो क्राइमहरू चाहिँ सदियों अघिदेखि चाहिँ चल्दै आइरहेका छन्। अब तिम्रो प्रश्नमा आउँदाखेरि चाहिँ अब यसलाई चाहिँ हामीले सिधै मिटिगेटिङ फ्याक्टरको रूपमा लियौँ भने त्यसको अब्युज हुन्छ कि हुँदैन भन्ने कुराहरूमा चाहिँ बेस्ट भएर भन्नुपर्दा चाहिँ हामीले सिधै अब एज ए सर्भाइभल क्राइमको क्लेम लिएर मात्रै त्यसलाई डिफेन्स दिन त मिलेन। अब त्यसमा चाहिँ एज इन अब जजेसहरूको पनि एउटा हात हुने भयो क्या। अब त्यसमा चाहिँ अब कति वर्षदेखि चाहिँ ऊ त्यसरी अब्युज भइरहेको छ, त्यसलाई चाहिँ एज एन इभिडेन्सियरी भ्यालुको रूपमा लिने हो कि होइन भनेर जजेसहरूले अस्योर हुनु पर्यो। त्यसपछि अर्को कुरा भनेको ल मेकर्सहरूले ल बनाउँदाखेरि पनि योसँग रिलेटेड लजहरू बनाउँदाखेरि एउटा छुट्टै ऐन ल्याउने हो कि छुट्टै नियमावलीहरू ल्याउने हो कि, किनभने यो त सजिलो कुरा त छैन नि त। किनभने यो भनेको त एउटा अब हामीले सर्भाइभल क्राइमकै रूपमा गऱ्यौँ भने अब भोलि गएर एउटाले ड्रग्स अब्युज गर्दैन, अब त्यसलाई चाहिँ हामीले बाँच्नकै लागि गरिरहेको छौँ भन्दाखेरि त त्यो त गाह्रो पर्न सक्छ नि त। त्यही भएर इभिडेन्सको रूपमा लिने हो भने चाहिँ अब यसको लागि रेगुलेसन गर्नको लागि एउटा छुट्टै लजहरू बनेपछि मात्र यसलाई चाहिँ हामीले एज इन जजको पावरमा पनि पेस गर्न सक्ने भयो। होइन भने चाहिँ अब यसको मिसयुज नहोस् भन्नको लागि चाहिँ अब यसको लागि अब हामीले कति टाइमको लागि यो हेर्ने हो भन्ने भयो। इकोनोमिक कजेसहरू के थियो भन्ने कुराहरू भयो, डोमेस्टिक अब्युजको कुराहरू भयो, त्यो महिलालाई अब के प्रेसरहरू परिरहेको भयो। अब अर्को इक्जाम्पलको लागि अब उसको सन्तानहरूको कुराहरू भयो, भविष्यको कुराहरू भयो होइन। यी सबै कुराहरूलाई लिएर चाहिँ एउटा छुट्टै हाम्रो ओपिनियन पनि के छ भन्दाखेरि एउटा छुट्टै ल बनाउन किन सकिँदैन त। अब जस्तै युकेमा पनि लजहरू बनिरहेको छ, अरू कन्ट्रीहरूमा बनिरहेको छ भने हाम्रो नेपालमा चाहिँ किन बन्दैन? एभिडेन्सियरी भ्यालुहरूलाई पनि लजमा इन्टिग्रेट गरेपछि हुन सक्छ भन्ने चाहिँ हाम्रो पनि ओपिनियन हो। त्यसरी चाहिँ हामीले यसलाई इन्क्लुड गर्न खोजेको हो।
Any more question?
आजको यस सेसनमा सहभागी साथीहरूले चाहिँ आफूसँग भएको ओपिनियनहरूलाई चाहिँ सेयरिङ गर्दाखेरि चाहिँ मोर डिस्कसन लाइभली होस् र हाम्रो नलेज इन्हेन्स। अघि हाम्रो सुरुवाती सेसनमा खासमा हामीले एउटा टपिक पछाडि क्वेसन एन्सर गर्दाखेरि चाहिँ मोर डिस्कसन अथवा चाहिँ त्यसले टाइम कन्ज्युम गर्ने भएको हुनाले हामीले यसरी गर्यौँ। तर हाम्रो कन्फरेन्सको मोटिभ चाहिँ के हो भन्दाखेरि तपाईँ हामीले जुन टपिकहरू चुज गरेका छौँ त्यो टपिकमा हाम्रो नलेज इन्हान्स गर्ने र तपाईँले प्रेजेन्टरहरूले प्रेजेन्टेसन गरिरहँदाखेरि तपाईँको माइन्डमा जे क्वेरिजहरू अथवा जे ओपिनियनहरू डेभलप भएको छ यु क्यान अल्सो सेयर द्याट काइन्ड अफ ओपिनियन है तपाईँको आफ्नो पर्सेप्सन हुनसक्छ र त्यो पर्सेप्सनलाई चाहिँ आइडियामा कन्भर्ट गर्नको लागि दिस इज द राइट प्लेटफर्म। ओके, अब धेरै साथीहरू चाहिँ एज अ प्रेजेन्टरको प्रेजेन्टेसनहरूबाट पनि धेरै कुराहरू चाहिँ क्लियर भइसकेको जस्तो छ र अब हाम्रो सेड्युल अनुसार चाहिँ आजको टपिक अथवा आजको विषयवस्तुलाई लिएर चाहिँ एज अ चेयर विषयवस्तुलाई चाहिँ म विषय केन्द्रित बनाउन चाहन्छु र आज समग्रमा हामीले 5वटा विषयमा टपिकहरूमा छलफल गऱ्यौँ। 5वटा विषयहरूमा यहाँ प्रेजेन्टरहरूले एकदम इन डेप्थ र इन्साइटफुल प्रेजेन्टेसनहरू गर्नुभएको छ। उहाँहरू सबै प्रेजेन्टरहरूलाई एकदमै थ्याङ्क्स भन्न चाहन्छु र अर्को चाहिँ उहाँहरूले जुन इन्साइट इन्फर्मेसनहरू यहाँ हामीले डिस्प्ले गर्नुभयो यसले पक्कै पनि एउटा क्रिमिनल जस्टिस सिस्टममा इम्प्रुभमेन्टको लागि उहाँहरूले ल्याएको रिकमेन्डेसनहरू फाइन्डिङहरूले पक्कै पनि यसले भाइटल रोल प्ले गर्नेछ भन्ने पनि आशा लिएको छु र विशेष गरेर हामीले पहिलो टपिकमा जुडिसियल डिस्क्रेसन एट द क्रस रोड अफ द ल एन्ड सोसाइटी केस स्टडी अन द इन्फेन्टिसाइड इन नेपाल भनेर हामीले डिस्कसन गऱ्यौँ र त्यो डिस्कसनमा पनि अरू प्रेजेन्टरहरूले प्रेजेन्ट गर्दै गर्दाखेरि कतै त्यो एक अर्कासँग चाहिँ रिलेटेड पोजिटिभ फ्याक्टरहरू पनि त्यहाँ भेटिन्छ र हामीले त्यो प्रेजेन्टेसनमा अझ एज अ लिसनरको रूपमा एज अ रिडरको रूपमा त्यो पेपरलाई हेर्ने हो भने त्यहाँनिर केही पोजिटिभ फ्याक्टरहरू चाहिँ अबोर्सनसँग सम्बन्धित कुराहरूलाई पनि त्यहाँनिर रिप्रोडक्टिभ अटोनोमी भर्सेस चाहिँ इन्फेन्ट राइटको विषयमा पनि अलिकति एनालाइज गरेको भए चाहिँ अलिक मोर प्रोडक्टिभ हुन्थ्यो कि जस्तो एज अ रिडरको रूपमा लागेको छ र कति कुराहरू त्यहाँ हजुरहरूले जुन फाइन्डिङ गरेको कजहरूमा चाहिँ जस्तै केस स्टडीबाट पनि हामीले त्यहाँ के पायौँ भन्दाखेरि इलिसिट चाइल्डहरू चाहिँ देखिन्छ र त्यो इलिसिट चाइल्डहरूलाई चाहिँ तपाईँहरूले प्रेजेन्ट गर्नुभएको केसहरूमा पनि त्यहाँ अबोर्सन चाहिँ अभोइड गरेको अबोर्सन रिजेक्सन गरेको कारणले गर्दाखेरि चाहिँ इन्फेन्टिसाइडको त्यो केसहरू चाहिँ त्यहाँ इमर्ज भएको जस्तो पनि देखिन्छ। त्यही भएर यो जुन पाटो रिप्रोडक्टिभ राइट भर्सेस चाहिँ इन्फेन्ट राइटलाई चाहिँ अलि एनालाइज गर्दै हाम्रो अबोर्सन लको जुन रिभ्यू गर्नुपर्ने पार्टहरूलाई पनि त्यहाँ जोड दिएको भए अझ पेपर चाहिँ मोर कम्प्रिहेन्सिभ हुन्छ कि जस्तो पनि मलाई लागेको छ है। त्यही भएर यो फर्स्ट पेपरमा हुन त उहाँहरूले धेरै इन्साइट जुडिसियल रिभ्यूको कुराहरूलाई पनि एनालाइज गरेर जुन कजहरू फाइन्ड आउट गर्ने त्यस्तै गरेर चाहिँ विभिन्न चाहिँ सोसियल फ्याक्टरहरूको कुराहरूलाई पनि जोड्नु भएको छ। एकदमै पोजिटिभ पार्ट चाहिँ जस्तो लाग्यो र अहिले अबोर्सन अथवा इन्फेन्टिसाइडका कुराहरू चाहिँ जुन क्रिमिनल पर्सेप्सन अथवा त्यो विषयवस्तुलाई चाहिँ हामीले सोसाइटीलाई कसरी इम्प्याक्ट हुन्छ र त्यो कुरालाई चाहिँ प्रिभेन्टिभ नेचरबाट चाहिँ कसरी लिएर जान सक्छौँ भन्ने तरिकाले अझ मोर त्यहाँ डिस्कसनहरू चाहिँ देखिन्छ। ओके, अर्को सेकेन्ड रिसर्च पेपरमा हामीले हेर्दाखेरि मोर चाहिँ अब प्याथोरोमन सिन्ड्रोम्स दिस इज भेरी न्यू कन्सेप्ट। हामीले नेपालमा ट्रेडिसनल कन्सेप्टलाई पिक गर्दै अहिलेको नयाँ क्रिमिनल लमा हामीले प्याथोरोमन सिन्ड्रोम्सलाई हामीले इन्ट्रोड्युस गरेका छौँ र त्यसमा पनि अझ विशेष गरेर यो केस स्टडीहरू अब 82सम्मकोमा आउँदाखेरि चाहिँ अझ इभेन्ट्सहरू बढी अकवर्ड चाहिँ पुरानै मुलुकी 2020 अन्तर्गत भएको हुनाले त्यहाँ मिटिगेटिङ फ्याक्टर यो अदलको व्यवस्था 188 को प्रयोग त्यहाँ देखिन्छ। हुन त हामी कहाँ अब जुरी मेट्रिक्स अथवा त्यो तरिकाको चाहिँ युनिफर्मिटी त्यो छैन, त्यसले गर्दाखेरि केही त्यसले भूमिका पनि खेलेको छ र मिटिगेटिङ फ्याक्टर्सहरू डेभलपको लागि चाहिँ जुडिसियल रिभ्यू अथवा जजहरू आफैले पनि त्यसले चाहिँ एउटा प्रब्लम चाहिँ गरेको छ। त्यही भएर यो न्यू रिकमेन्डेसनमा चाहिँ सेकेन्ड रिसर्च पेपरको चाहिँ सबभन्दा बेस्ट फाइन्डिङ पार्ट चाहिँ के आयो भन्दाखेरि उहाँहरूको रिकमेन्डेसनहरू चाहिँ बेस्ट पार्ट चाहिँ जस्तो लाग्यो। एज स्ट्रङ्गेस्ट पार्ट चाहिँ जुन ट्रेडिसनल क्रिमिनल जस्टिस भर्सेस मोडर्न यो सर्भाइभल एप्रोचहरूलाई लिएर जुन कुराहरू गर्नुभएको छ त्यो एकदमै बेस्ट एप्रोच लाग्यो। र यसले चाहिँ एउटा मिटिगेटिङ फ्याक्टर्सहरूलाई चाहिँ कसरी चाहिँ न्यू मोडर्न ट्रेन्ड्सहरूलाई चाहिँ कसरी एडप्ट गर्दै लानुपर्छ भन्ने कुराहरू उहाँले गर्नुभएको छ, एकदमै बेस्ट पार्ट त्यो जस्तो लाग्छ। अर्को थर्ड पार्टमा हामीले यो रिप्रोडक्टिभ अटोनोमीको कुराहरूमा चाहिँ यो अवर्सनका कुराहरू जुन कुराहरू छ, अवर्सन यो नलेज डिसिमिनेसनका कुराहरू हुन त हाम्रो सोसाइटीमा अलि बढी चाहिँ रिप्रोडक्टिभ हेल्थ भन्दा पनि अलि सेक्सुअल एजुकेसन अलि बढी चाहिँ कुराहरू हुन्छ। तर रिप्रोडक्टिभ हेल्थको कुराहरू गर्दाखेरि चाहिँ अलिकति सोसाइटीले पनि अथवा त्यहाँ सोसाइटीभित्र रहेका हामी मेम्बर्सहरूले पनि त्यसलाई चाहिँ प्राथमिकता नदिएको जस्तो र इभन हाम्रै सोसाइटी फ्यामिलीमा पनि त्यो रिप्रोडक्टिभ हेल्थलाई नर्मलाइज गर्न नसकिएको कुराहरू पनि छ। अब अलिकति त्यहाँ मेन्सुरेसनका कुराहरू चाहिँ मेन्सुरल हाइजिनका कुराहरू चाहिँ अलि नर्मलाइज हुँदै आएको छ अहिले हाम्रो सोसाइटीमा। तर स्टिल चाहिँ रिप्रोडक्टिभ हेल्थ फ्यामिली प्लानिङका कुराहरू अनि अन्य विषयवस्तुहरू चाहिँ नि त्यो कुरालाई चाहिँ हामीले एज अ कज अफ फ्याक्टर हो अथवा यो रिप्रोडक्टिभ अटोनोमीका कुराहरूलाई चाहिँ एउटा क्राइममा कन्भर्ट प्रिभेन्सन गर्नको लागि चाहिँ त्यसलाई चाहिँ हामीले यो रिप्रोडक्टिभ एजुकेसन भर्सेस सोसियल एजुकेसनको विषयहरू बस्नुलाई पनि त्यो टपिक बनाएर पेपर प्रेजेन्टरले अझ मोर एनालाइज गरेको भए चाहिँ अलि मोर इन्साइट इन्फर्मेसनहरू चाहिँ फ्लो हुन्थ्यो जस्तो मैले फिल गरेको छु। र त्यसमा पनि विशेष गरेर यो ल्याक अफ एजुकेसनका कुराहरू र अहिले रिप्रोडक्टिभ हेल्थ हाम्रो एजुकेसन सिस्टममा त राखिएको छ र त्यो एजुकेसन सिस्टममा राखेका कुराहरूमा पनि हामीले अर्को रिसर्च चाहिँ आवश्यक छ। त्यसले कतिको इम्प्याक्टफुल काम गरिराखेको छ, त्यो एउटा एजुकेसन कोर्सको रूपमा राखिएको मात्र छ कि अथवा त्यसले चाहिँ रिप्रोडक्टिभ हेल्थ र त्यो एजुकेसनले चाहिँ यता क्राइमहरूमा अथवा त्यसले चाहिँ कतिको इम्प्याक्ट खोलेको छ भन्ने कुरा पनि अर्को रिसर्च आवश्यक जस्तो मलाई महसुस भएको छ। र त्यसमा यो लिगल अमेन्डमेन्टका कुराहरू चाहिँ एकदम अहिले यो रिप्रोडक्टिभ अटोनोमीका विषयवस्तुहरूलाई लिएर चाहिँ एउटा सेपरेट लिगल अमेन्डमेन्ट हुनुपर्छ अथवा अबोर्सनहरूमा पनि कतिको त्यो डिफाइन गर्ने जुन कुराहरू छन् त्यो विषयलाई पनि एकदमै राइटली मेन्सन गर्नुभएको छ। अर्को फोर्थ प्रेजेन्टेसनमा हाम्रो प्रस्टिट्युसनको केसलाई एउटा लिगलाइज गर्ने अथवा क्रिमिनलाइज गर्ने यो विषय पहिलेदेखि पनि एज अ कन्स्टिट्युसनल मेकिङ प्रोसेसदेखि पनि त्यो कुराहरू उठ्दै आएको थियो। 2065देखि नै यो विषयवस्तुलाई चाहिँ यो पोलिटिकल मेन स्ट्रिममा आइसकेपछि अब इकोनोमिक डेभलपमेन्टसँग पनि जोड्नुपर्छ अथवा यो प्रस्टिट्युसनलाई चाहिँ कति धेरै विषयवस्तुहरू चाहिँ डेभलपमेन्टसँग पनि जोडिएर हेर्ने गरेको छ। जस्तै टुरिज्म डेभलपमेन्ट र यतातिर प्रस्टिट्युसनका कुराहरूलाई पनि टाइम एन्ड अगेन कुरा गर्दै आएको छ। र त्यो कुराहरू चाहिँ यो यसलाई लिगलाइज भर्सेस क्रिमिनलाइजेसनको कुराहरू छ। अहिले नेपालको लले त्यसलाई एउटा क्रिमिनलाइजेसन प्रोसेसमा लगेको छ र पेपर प्रेजेन्टरहरूले यसको क्रिमिनलाइजेसन गरे पनि यसलाई रोकथाम गर्न सकिएन अथवा त्यसको विभिन्न कजहरू फ्याक्टरहरूको बारेमा चाहिँ डिस्क्राइब गर्न खोजेको छ। र त्यसमा चाहिँ जस्तै त्यहाँ प्रस्टिट्युसनलाई चाहिँ अगाडि बढ्नुको कारण इकोनोमिक फ्याक्टर विशेष गरेर त्यो कुराहरूलाई औल्याउनु भएको छ भने अर्को उहाँहरूले चाहिँ यो सोसियल कल्चरका कुराहरू यो कल्चरल प्र्याक्टिसेसका कुराहरूलाई पनि उहाँहरूले जोड्न खोजेको छ। इभन दो यो कन्स्टिट्युसनलाई चाहिँ यो जहिले पनि एउटा टाइम एन्ड अगेन यो इस्यु चाहिँ जहिले पनि यसलाई लिगलाइज गर्ने हो अथवा क्रिमिनलाइज गर्ने हो भन्ने कुरा चाहिँ स्टिल चाहिँ यो डिस्कसनको टपिकै छ र यो विषयलाई पनि एकदम राइटली मेन्सन गर्नुभएको छ। त्यस्तै गरेर लास्ट पेपर प्रेजेन्टेसनमा पनि सोसियो इकोनोमिक फ्याक्टर जुन सर्भाइभल क्राइमहरूलाई चाहिँ एउटा सेपरेटली डिल गर्नुपर्छ, लिगल रिफर्महरू गर्नुपर्छ र त्यो कुराहरूलाई चाहिँ एउटा सेपरेटली लग्दाखेरि एउटा मिटिगेटिङ फ्याक्टरहरू जसरी चाहिँ डेभलप गर्न हेल्प हुन्छ भन्ने कुराहरू छ। त्यो पनि एकदमै राम्रो तरिकाबाट प्रेजेन्टेसन र पेपर राइटिङ गरेको जस्तो महसुस भएको छ। सम्पूर्णहरूलाई वन्स अगेन थ्याङ्क्स र तपाईँहरू सबैले चाहिँ बेस्ट विसेस फर यर फ्युचर्स पनि भन्न चाहन्छु। हस्, थ्याङ्क यू।
Thank you, Chairperson of the panel, Advocate Rajan sir. Thank you all of paper presenter and participant which is present in this session. अब क्रममा भनेको हाम्रो सर्टिफिकेट डिस्ट्रिब्युसनको प्रोग्राम रहेको छ जसमा प्रेजेन्टरहरूलाई चाहिँ हामी यो प्यानलमा नै सर्टिफिकेट डिस्ट्रिब्युसन गर्ने कार्यक्रम रहेको छ। बाँकी पार्टिसिपेन्टहरूलाई चाहिँ हाम्रो सबै सेसनहरू कम्प्लिट भइसक्यो भन्दा पछि बेलुका मात्र हामी डिस्ट्रिब्युसन गर्नेछौँ। अबका क्रममा पार्टिसिपेन्ट पेपर प्रेजेन्टरहरूलाई चाहिँ सर्टिफिकेट डिस्ट्रिब्युसन गरिदिनु हुन यस सेसनका चेयरपर्सन आदरणीय राजाराम सरलाई म अगाडि बोलाउन चाहन्छु। त्यसै गरी सर्टिफिकेट ग्रहण गरिदिनु हुन साइबा थापा र खुसबु यादवलाई म अगाडि बढाउन चाहन्छु। त्यसै गरी प्रतिष्ठा ढकाल, सुस्मिता खड्का, शुभेच्छा बराल, कृपा घिमिरे, अनिस अधिकारी, सुदेश भुयाल, ग्रीष्मा बल्ला, स्वस्तिक राई, धन्यवाद आदरणीय सर परिवर्तन आदरणीय सर र सम्पूर्ण पेपर प्रेजेन्टरहरूलाई अबको सेसनमा यस सेसनका सेसन चेयरपर्सन आदरणीय अधिवक्ता राजाराम दुवाल सरलाई टोकन अफ लभ दिने कार्यक्रम रहेको छ। टोकन अफ लभ प्रदान गरिदिनु हुन पोको कलेज अफ लका प्राचार्य आदरणीय म्याम अन्दाज दाजुलाई अनुरोध गर्दछु र ग्रहण गरिदिनु हुन आदरणीय सर अधिवक्ता राजाराम दुवालजीलाई अनुरोध गर्दछु। सम्पूर्ण महानुभावहरूमा उपस्थित भइदिनु भएकोमा खोपो कलेज अफ ल परिवारको तर्फबाट हार्दिक कृतज्ञता ज्ञापन गर्दै यो सभा यही समापन भएको जानकारी गराउँदछु। यसभन्दा पश्चात लन्च ब्रेक रहेको छ। लन्चको लागि हामी फर्स्टकै क्यान्टिनमा उपस्थित हुनेछौँ। थ्याङ्क यू। मोडरेटर, ऱ्यापोर्टर, पेपर प्रेजेन्टर लागि अगाडि
Hello.